Thank you, Madam Chair, members of the body. You know, I'm sure we can all agree that parents normally have the fundamental right to control their children's upbringing. But Montana's Constitution says that children also have fundamental rights, and specifically including the rights to safety, health, and happiness. And that's a quote. So in committee, we heard from pediatricians, educators, family law attorneys, and those who advocate for abused children. All testify that this bill will place children's rights to safety, health, and happiness at grave risk. And that's why I rise today to oppose this bill. First, it's important to understand what this bill is not about. Section 2 of the bill says, and you're welcome to read along with me, this section may not be construed as invalidating the provisions of Title 41, Chapter 3, or modifying the burden of proof at any stage of those proceedings. So that's the chapter of code that controls abuse and neglect proceedings. So this bill doesn't affect abuse and neglect cases in any way, as the carrier just acknowledged. But perhaps unintentionally, the bill does have serious impacts on children by upending many other areas of law and policy. Take family law. In these cases, a judge is currently required to give very high priority to the best interests of the child. But this bill would elevate the parent's interests above that of the child, overturning this rock-solid and fundamental rule of our family law system. Not only that, but parents often disagree about children's upbringing in these highly contentious cases. Which parents' fundamental rights will be honored? In committee, family law attorneys with decades of experience explained how this bill would disrupt parenting plans that try to resolve parental disputes about a child's upbringing, especially disputes about education and medical care. They told us that we can expect disgruntled parents to flood our courts with the lawsuits that this bill authorizes, which is why the fiscal note says, net impact unknown. Apart from family law, this bill upends Title 20, the code concerning public schools, which establishes relationships between schools, parents, and students. We heard from school boards, superintendents, and other statewide education groups who told us that while they support parental rights, and we all do, they oppose this bill because it would override truancy laws, curriculum matters, school discipline, and a host of other areas that impact public schools. Montana's pediatricians also came in, and they told us how this bill endangers children's health and mental health, limiting adolescent privacy and confidentiality from youths who seek health care and mental health care. Without confidentiality, they said, some youths will be less likely to seek medical care, and especially mental health care, putting them at risk. Youth rights of privacy in their medical treatment and records will go up in smoke under this bill. We heard from a lawyer who specializes in seeking orders of protection for abused children, usually against a parent or a parent's partner. This lawyer told us how this bill would give parents the right to file an action to stop those actions, while also allowing actions against a judge who is trying to keep a child safe. Even parents who are absent or have no relationship with a child would have rights that can prevail over the child's best interests, according to this bill. And finally, Montana's organizations that advocate to protect children from abuse and neglect were adamant that this bill, and I'll quote, puts children at serious risk and could create generations of harm. I appreciate the intention of the sponsor, and as I said, we all support parental rights. But this bill does not really address her concerns and causes many unintended consequences which spill over in ways that make our children unsafe. For our children, I urge you to please vote no. Thank you, Madam Chair. Representative, thank you for that really thoughtful question. Coming from a great lawyer, I appreciate it. You know, I very much agree with the good representative from Hamilton in C2 that the problem is we never really know what a compelling governmental interest is or a narrowly tailored rule until a court gets it before it and then has to decide it. But and it's hard to decide as between the potential impacts on family law cases, on mental health of children and physical health, on education, which is the most troubling part. Any one of them could be severely impacted by this. And there is no way for you or I to predict, as great a lawyer as you are, precisely what interest a court will say is a compelling government interest at the end of the day. Sure, there is a compelling government interest in keeping children safe, but what happens in a family law case when there's a dispute, and you, I'm sure, know that those cases are highly contentious and very facts thrown all over the place, and and the parent says, my fundamental right is higher than the right of the best interest of the child, which is the standard now. What happens? We don't know. And that's why the folks who came in, all of whom, unanimously, who are the experts in this area, in every aspect of this area, all came in so opposed to the bill. That's why when I said education officials, it included school boards and superintendents and other educational leaders in the state who said, we don't know how this bill will affect our curriculum. So we teach a particular subject and a parent comes in and says, we don't like that you're teaching evolution. You've got to stop teaching our kids evolution and create a special class for evolution, for example. And I'm just picking that as one particular topic. It could be any topic. Or truancy laws. Is that a compelling interest? Maybe, and maybe not. Or maybe in some circumstances it is, or some circumstances it's not. I don't see, I guess I could throw the question back and say, what is the problem that we're trying to address that this bill does that's worth it, when we all know that parents have rights, when at risk are all these areas that can cause harm to children? I hope I've answered your question, good representative.
Yeah.
So the proponents in this hearing, every single one of them, came in to complain about some aspect of a child abuse and neglect proceeding that they felt was not fair to them. And to me, it was the most curious hearing because the bill itself specifically excludes any application to child abuse and neglect proceedings. And so there was a family law attorney there also who was asked, well, what about these proponents who are having issues with these abuse and neglect proceedings that they say it violates their parental rights? And she said, and I quote, that by virtue of Section 2 of the bill, SB400 doesn't solve any of the proponents' issues. So it got curiouser and curiouser in that all of the proponents were concerned about these CPS proceedings when the bill has nothing to do with CPS proceedings, as the good carrier acknowledged when he first stood up. So that's a red herring. I appreciate the good representative from Kalispell raising it as it was raised in the hearing, but it is completely a red herring, and we shouldn't be influenced by something that has nothing to do with the bill. Thank you, good representative, for the question. Thank you, Madam Chair.